Welcome everybody. We've just opened the live link, so we'll just be waiting for a few minutes to allow everybody to join before we start. Good afternoon and welcome to the Five Stone Buildings webinar programme. We just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start.
Okay, good afternoon, everybody. My name's Ruth Hughes and this is Tom Entwistle, and today we're going to be talking about Variation of Trusts Act applications. This is going to cover the basics of when a Variation of Trusts Act application can be used, the idea of benefit, postponing a minor's interests, procedure and practical tips, privacy, whether you really need a VTA, and what you can get from a VTA that you can't get from anything else. And then there will be some time for questions. So the reason the Variation of Trusts Act was needed is because there's no way for some kinds of beneficiaries to consent to changes in trusts, and the court has no inherent jurisdiction to do that on their behalf. The Variation of Trusts Act is essentially very short. It allows permission to be given for a change in trusts on behalf of incapacitated adults, children, unborns and unascertained or people with future interests that have not yet vested, and discretionary beneficiaries underneath protective trusts that are extant, although that's now pretty rare because protective trusts are quite rare. Normally the kind of applications you see will be on behalf for variation on behalf of children or unborns. All except the protective trust category requires there to be a benefit for the person or the class that permission is being sought on behalf of to vary the trust. I did have a case recently where Master Marsh was willing to undertake a variation, even though some of the remote beneficiaries did not consent, hadn't asked to consent, on the basis that it was for the trustees to decide if they were willing to undertake a judicious breach of trust and ignore those interests. But in general, you're going to need all the adult beneficiaries of the trusts to consent to the variation as well. In terms of what benefit is required, neutral is not enough. And if you're going to need a benefit for your class, even if the class is extremely unlikely to exist. If they do come into existence, then they will need to have a benefit from the variation. Sometimes this will mean that there is a part of the trust which is demarcated and earmarked for the class that might never come into existence. And this can therefore be expensive for the other beneficiaries of the settlement, and that's sometimes a reason why variations are not made, because the other beneficiaries do not want to provide that benefit to the unlikely to exist class. The disbenefits of a package of variation can be outweighed by gains, and the court will look at the arrangement as a whole. The benefit, there doesn't have to be a benefit in all possible worlds in order for the variation to be of benefit. And there can be discretions given that may or may not benefit particular members of a class. So, for example, the trustees may be given a discretion under the variation to benefit a class involving A, B, and C. And this is going to be maybe for the benefit of A, B, and C, even though the trustees could decide to benefit only A later and not B or C. So that can be a benefit for that class. You are going to have to make sure that isn't any conflict within your class though, because that will require separate representation and separate benefit. the court will allow there to be some kind of risk taken on behalf of minors or unborns, particularly if a reasonable adult will be willing to bear the same kind of risk. So, for example, you can get short-term transitional serial interests or spousal immediate post-death interest in possession inserted into trusts to get tax relief from spouse relief for inheritance tax, even though this will shut out children from income of the trust for a number of years, and even though it's possible that the spouse might die, and so there won't be inheritance tax benefit after all, if you would expect there to be a benefit at the end of the day for the children. Common examples of variations you get asked to make are partitions of the trust fund, where there's a life tenant and remainder men, and the remainder men are usually the children. And whilst Lewin says that you need to benefit the remainder men not only by the accountancy benefit of their interest, the capitalized value of their remainder interests, you also need a sudden death benefit, so they'd be better off if the life tenant died tomorrow. In practice, in my experience, the court will accept that a benefit in capital terms is much less than the sudden death benefit, so that is, in my view, too conservative a view. You may want to avoid vesting, and Tom is going to talk about vesting, avoiding vesting in a minor in a minute. You may want to get other tax benefits, and for example, the variation I was talking about earlier that I did in front of Master Marsh, that was to allow more flexibility within the trustees' discretions to allow them to appoint capital to offshore beneficiaries to obtain a capital gains tax advantage overall. You may want to change intestacy trusts. And now Tom is going to talk about particularly applications to postpone a minor's interest.
Thank you. This is quite a common type of application under the VTA. Broadly speaking, there are three types of application to postpone, though these categories quite often overlap in practice. The first type is the case of the prodigal child. The second I'm going to call too much, too young. And the third type is the sort of case where it's simply hoped to mitigate tax. Prodigal child cases are those in which the application is based on the particular personal characteristics of the beneficiary. Often the beneficiary is unusually immature or improvident, or has some particular issue such as drug use. It's in the nature of these cases that the applications are often made when the beneficiary is in their mid to late teens, and so relatively shortly before they reach adulthood. Quite commonly, an application has to be made urgently because the family suddenly realizes that their troubled child or grandchild is about to come into a substantial fortune in a matter of months or even weeks. An example of this sort of case is Re T, in which the beneficiary would have become entitled to her share in the trust fund about a fortnight after judgment was given. She was said to have shown herself to be alarmingly immature and irresponsible as regards money, though no detail of this is given in the judgment. As the application was originally formulated, she would have been deprived of any entitlement to capital at all, and would have been given only an income interest under protected trust. But the judge thought that this went too far and amounted to a resettlement rather than a variation, and anyway said to be for the child's benefit. But the court did approve a revised proposal under which she would initially be entitled to income only, but would take capital later on with the power of advancement in the meantime. The too much, too young cases, which is second category, differ from the prodigal child cases in that they don't depend on any particular characteristics of the actual beneficiary concerned, but rather on the general proposition that it doesn't benefit someone to come into a lot of money at the age of 18. And applications of this sort are often made when the beneficiary is a young child. An example of this second sort of case is Re Holt, in which the trust fund was held for the settlor's daughter for life and subject to that for her children on attaining 21. The proposal was that the daughter would surrender her life interest in half the fund, and the children's interests would be postponed so that they would receive half the income at 21, the other half at 25, and capital at 30. Most of the judgment is concerned with technical questions relating to the perpetuity period, which I'll come back to a bit later on. But the judge briefly considered the question of benefits to the children, which he said was overwhelming. This is partly for purely financial reasons, since there was a tax saving available on their mother's death, and their interests in the half the fund in which her interest was being surrendered would be accelerated. But he also agreed with the mother's stated view that, and I'm quoting from the judgment, speaking in general terms, it's most important that young children should be reasonably advanced in a career and settled in life before they're in receipt of an income sufficient to make them independent of the need to work. The judge described this as moral or social benefit as opposed to financial, and indicated that this could satisfy the benefit requirements under the BTA. An example of the third sort of application, which was purely motivated by potential tax saving, is Ridgewell, in which the trust fund was held on life interest trusts with remainder to the beneficiary children. It was proposed to insert a successive life interest in favour of the beneficiary's spouse. In one sense, this was obviously contrary to the children's interests because their entitlement to capital would be postponed. That factor was outweighed by the inheritance tax treatment. The successive life interest would avoid an IHT charge on the life tenant's death, and it would hopefully allow time for the fund to be distributed to children in the future without incurring any IHT liabilities. And on that basis, the court had no difficulty in approving the proposal as being for benefit. A more recent case in which a child's entitlement was postponed was Wright and Gator, which sheds some light on the court's present attitudes to these applications. In that case, the beneficiary was aged 3. His grandfather had died almost 2 years before the application was made, and his father died the year after that. Both grandfather and the father had died intestate. So the child beneficiary was entitled to the grandfather's estate via the father. And this gave rise to 2 problems. The first was that the grandfather's estate was effectively subject to IHT twice, being taxed on both deaths. And secondly, the child's mother felt that it was not in his interests to receive his entitlement to 18, provided for by the intestacy. So a proposal was put before the court which had 2 elements. The first was to vary the effect of the intestacy rules on grandfather's death so that his estate would pass directly to the child rather than going through the father's estate. This would be treated retrospectively for IHT purposes as long as the order was made within 2 years of grandfather's death, and so it would avoid the double charge problem. And the judge said that this first aspect of the arrangement was entirely straightforward. More problematic was the second proposal that the child's right to capital should be postponed to age 30 with a power to accumulate income until then. Rather like in the older case of Re T, the judge clearly felt that this proposal went far. He said that the cases didn't establish that postponement of a child's interest beyond the age of majority was beneficial in principle, and that this would need to be established in each case on the evidence. And in this case, there was insufficient evidence by such a lengthy postponement. But again, as in Re T, the judge was content with a revised proposal under which the child would be entitled to income at 18, 10% of capital at 21, and the balance of capital at 25. So despite the judge's clear rejection of any sort of general principle that interests should be beyond age 18, or that is inherently for benefit, Wright and Gator is, I think, more helpful in applications of this sort than it perhaps seems at first sight. The judge accepted that the concept of benefit under the BTA extends Reholt as moral benefit. In fact, he said that on the not terribly unusual facts of Wright and Gator, any reasonable person would regard it as posing risks if he became entitled to it at 18. And obviously, since the beneficiary was only 3, this wasn't based on any evidence of his own to handle money, and therefore must have been based on some sort of general position. On the other hand, it's also clear from Wright and Gator, in keeping with the older cases, that the courts will look to keep arrangements of this sort within reasonable bounds. Although what's realistic in a particular case is both fact-specific and to some extent judge-specific, I've certainly found that postponement until age 25 is usually accepted without too much difficulty, whereas going beyond that can be rather more of an uphill. And so now I will hand back to Ruth.
Thanks very much, Tom. I think that we can summarise the too much too young as you should be getting a wife and kids, not having any fun. I'm going to talk a little bit about some procedural points in relation to Variation of Trusts Act applications. Obviously, the normal Variation of Trust Act application happens in the High Court, although if you have an adult who lacks mental capacity, you need to be in the Court of Protection. There are some children who will lack capacity when they grow up, and they can have a deputy, but your application in relation to them ought also to be in the High Court, not in the Court of Protection. It used to be the case that almost always you would get these cases in front of a High Court judge, but now, since the Briggs Review, you're much more likely to get a master deciding your Variation of Trust Act application. If you have a case where you have children or unborns and an adult lacking capacity, what you're going to need is a Chancery Division High Court judge who is also sitting as a judge of the Court of Protection, wearing 2 hats. And this is what Mr. Justice Whitehall would look like if he were deciding such a case. Because of the change from the High Court judges to the masters have taken over the gateway to listing, and so listing can be a little bit more tricky in an emergency. So bear that in mind in the timescales you're undertaking. Things can be done quickly, but bear in mind that listing isn't as easy as it used to be. What you're going to want for a classic High Court Variation of Trust Act application is a Part 8 claim form and a witness statement. Normally these applications are bought by the trustees, but they can be bought by the settlor or an adult beneficiary. And you're going to need to exhibit the settlement, any other trust documents altering the settlement, like deeds of appointment or advancement that are relevant, any other previous variations, trust accounts, and any other material that you think is needed to establish a benefit on behalf of the minor or class. So, and there may be any amount of other things to assist in doing that. So as I said, do plan ahead if there's a vesting or other deadline, because it's easier to do it not at the last minute. Seek assistance from the clerks early to get listing in advance and see if that's possible. Choose an appropriate litigation friend for your minor. So I did a case where unfortunately, the litigation friend was a footballer's wife, and she decided that she was going to go Christmas shopping rather than sign the evidence that was needed saying that she supported the variation. So my solicitor had to go and find her in Westfield in the middle of the Christmas shopping pandemonium because we had to get the case on before Christmas. So choosing an appropriate litigation friend is a good idea. You may well be able to instruct counsel for the trustees and the minors and other parties from your firm, that you're going to need to put in place a Chinese wall to do that. You want to get counsel's assistance from the minors or unborns as early as possible. This is because they might have views on the drafting of the settlement, and as Tom said, you're not allowed a resettlement, so take that into account. The counsel for the unborns may want to consider whether they can represent the whole class you want them to represent, because there may be conflicts within the class. That can exist, for example, where you have a remainderman class of children with substitutionary beneficiaries if they don't survive for a particular period, and so you have been intending to benefit children in a particular way, but that's actually to the disbenefit of their unborn substitutionary children, and so that can cause there to need to be more than one class, and so you're going to need more than one counsel and more than one set of benefit. It's sometimes counsel will have views on the evidence to be put forward in relation to benefit, and will be asking for separate additional evidence in relation to that. And of course, counsel will need time to write her opinion, and all that should be done before issuing, so that you have all your ducks in the row, and also so that the adult beneficiaries can agree to the final form of settlement that's proposed by the that's agreeable to the counsel for the unborn or minors. And you also might want to think about whether or not you're going to have a public or private hearing, which Tom is now going to address.
Yes, thank you. Perhaps not surprisingly, there are often concerns about privacy when applications are made under the VTA, because the evidence generally contains material which is confidential or sensitive in one way or another. Although the general principle that justice is to be dispensed in public has always applied to VTA applications, the fact that many of the cases are known only by the parties' initials is a pointer to the fact that in practice, things have operated a little differently. There have been two recent decisions in which privacy has been considered. The first is V against T, in which the applicant applied for an order that the hearing should be held in private on several grounds. It was said that the value of the trust fund was much higher than is usual. No detail of that, one can only imagine. The evidence included information about a private company which could be exploited by its customers potentially if that information entered the public domain. And it was said there were minor beneficiaries who didn't know the enormous extent of the family's wealth, and it would be damaging for them to find out at too young an age. The judge, who was Mr. Justice Morgan, declined to hear the application in private. He said that the general rule was a fundamental principle of open justice, and that clear and cogent evidence would always be required to justify any departure from it. He was clearly pretty unimpressed by the evidence of commercial sensitivity, described as thin. He was rather more persuaded by the need to protect the minor beneficiaries, but he still held that this didn't justify a privacy order. Instead, he decided that their interests could be appropriately protected by imposing reporting restrictions and also by preventing the public from obtaining documents from the court file except with the court's permission. And this perhaps more restrictive approach was endorsed by the Court of Appeal in the second case, MN against O, in which the parties argued that the default position on VTA applications should be for them to be held in private, by analogy with approval hearings on behalf of children. The Court of Appeal rejected that analogy, saying that although VTAs did often involve private information, this was generally of a much lower order of sensitivity than the medical and other highly personal evidence that was often before the court in approval hearings. But although the Court of Appeal therefore upheld the refusal at first instance to make a privacy order. It did reverse the judge's refusal to make any form of anonymity order at all, though the one made in this case was rather less extensive than in V&T, in that it only prevented the minors from being identified. There were no restrictions on naming the adult beneficiaries or reporting on the nature or value of the trust. And that reflected the fact that the court said that the evidence was less than it had been to justify the more extensive restrictions that were imposed in V&T. So it's clear, I think, from these cases that the courts will not make privacy orders on VTA applications simply as a matter of course, as perhaps used to be the case at one time. But in practice, they are still quite often made. And even if a full privacy order isn't available, the court will often be prepared to make an anonymity order, which in practice is usually good. Where a VTA application does give rise to concerns of this sort, the Chancery Guide says that a without notice application should be made to the master before the claim is issued. So the parties should have quite a good idea what is and isn't going to enter the public domain before the final hearing takes place. The cases suggest that the focus of the evidence in support of any application anonymity should be the potential impact of publicity on minor beneficiaries, as this seems to be the most likely factor to persuade the court to make orders. And I'll hand back to Ruth again.
Yeah, I completely agree with that. I had some anonymity orders made in a variation that I did, and the evidence we had was that the children's father, who was the deceased, had committed suicide in relatively public circumstances, and there had been quite a lot of publicity over that, and it had been damaging to the children, and it was likely that the press would become interested in it again if there was any suggestion of a public hearing without restrictions. So that's one we managed to obtain. So I'm now going to talk about whether or not you really need a variation at all. It may be that you have a trust power that you can use to change the trusts of the instrument. In particular, do you have an extended section 32 power to allow you to advance for the benefit of the capital beneficiaries? I've certainly had variation of Trusts Act applications that have been suggested to me, which can be dealt with a great deal more simply and at less cost and quickly by using that section 32 power to advance. Provided your trustees feel comfortable to do that without a blessing from the court, then it's going to be much more sensible to use that power than undertake a variation. It's also possible that you might be able to change the terms of your trust using an application under the Inheritance Provision for Family Independence Act 1975, and that might be particularly useful if you might want to have retrospective tax relief more than 2 years after death under section 146 of the Inheritance Tax Act 1984. So those are some circumstances where you might want to use something else and not a variation of Trust Act application. And I think, Tom, you said you were going to come back to the perpetuity period. Do you want to deal with that, or do you want me to?
Yeah, I'm happy to deal with that. This really is it's just a brief mention of a particular use that can be made of the VTA, which is to extend the perpetuity period of a settlement. This is perhaps slightly surprising at first blush, but there have been several cases over quite a long period now in which this has been done, of which the first is the case that I mentioned earlier in a different context, re Holt. This was decided shortly after the 80-year perpetuity period had been introduced by statute in 1964. And in that case, the judge held that although the original settlement long predated 1964, the order under the VTA effectively restarted the perpetuity period, and not only that, but could take advantage of the new fixed period under the 1964 Act. And the same now applies to the Perpetuities and Accumulations Act 2009. So in the same way, advantage can be taken of the new 125-year period if a VTA application is made. And this can quite often be useful to extend the lifetime of a trust, which in particular is often desirable to avoid a CGT charge, which might arise when ends. And this is what happened in both of the other two cases on the slide, Wyndham and Egremont, and Alfrey and Alfrey. And both of those cases contain a useful discussion of whether an order which inserts a new perpetuity period is itself a resettlement. If that were so, then the order itself would cause a CGT charge, and so would defeat the purpose of an application which was motivated by intent to save tax. Helpfully, in both cases, the court said that the order would not amount to a resettlement. It would only be a variation of the sort authorised by the Variation Act. And in fact, in all three, it seems that HMRC had already indicated before the hearing that it accepted that any order that the court made would be a variation rather than a resettlement. So it's clear, therefore, on the authorities, first, that the VTA can be used effectively to reset the clock for perpetuity purposes, which can be useful. And secondly, that will, or at least can be drafted in such a way that it will nevertheless only amount to a variation and not a resettlement for CGT purposes. There's perhaps an element of having one's cake and eating it about about that treatment, but there we are. That's what the cases say, and it seems helpful to those who are looking to avoid CGT in those sorts of circumstances.
Thanks very much, Tom. We now have time for questions. We already have one question, which is, can a Variation of Trusts Act application be used to bring a trust to an end? The questioner has a trust where the entitlement to absolute vesting in capital is delayed, and there are some substitutionary beneficiaries. There's no reason why a Variation of Trusts Act in that circumstance can't be used just in the same way as a partition between a life interest and capital beneficiaries, provided the substitutionary class benefit. So I think that a Variation of Trusts Act can be used to bring a trust to an end like that, and it commonly is. If anybody else has any questions, please do put them in the Q&A box. If you don't want to have your name read out for the video, please say that you'll want to be anonymous. So I don't think that we have any more questions. So thanks ever so much, Tom, for doing the Variation of Trusts Act webinar with me. And I hope to see some people at a talk soon in real life if this lockdown ever ends. So goodbye for now.